Chapter 4 Estates for Life. For all the purposes of merger, an estate tail after possibility of issue extinct is classed among estates for life and is susceptible of merger as such. In Lewis Bowles' case, it was agreed that tenant in tail after possibility of issue hath a greater preeminence and privilege in the quality of his estate than tenant for life, but he hath not a greater quantity of estate than tenant for life. In respect of the quality of his estate, it tastes too much of the quality of an estate in tail out of which it is derived. But as to the quantity, he hath but an estate for life, and, therefore, if he maketh a forfeit in fee, it is a forfeiture of his estate. So if fee or tail general descend or remain to tenant in tail, after possibility, and c. the fee or estate tail is executed, that is, come into possession by the merger of the estate tail after possibility, and c. and by the statute of Westminster 2nd, he in reversion shall be received upon his default, and an exchange betwixt tenant for life and tenant in tail after possibility is good, for their estates are equal. So, where land was given to W. and A, his wife in special tail, remainder to I. N. in tail, the remainder to the right heirs of I. N. The baron died without issue, and A. the feme survived and became tenant in tail after possibility of issue extinct, and took another husband and had issue, and after I. N. died without issue, to whom the feme is heir, and she died, the second husband shall be tenant by the courtesy, for when the remainder in fee came to the feme tenant in tail after possibility of issue, the freehold was extinct in the fee, and so A. was seized in fee. There are no decisions to show that an estate tail, after possibility of issue extinct, will merge in another estate of that kind. In truth, whether such a merger would take place, involves the question, whether equal estates will merge in each other, and this we shall consider presently. It is clear that estates for life are affected by the doctrine of merger, and may be lost or extinguished in estates in fee. Thus, if there be a limitation to a for life, with remainder to him in fee, the life estate has no legal existence. It is merged or drowned in the estate in fee. And an intervening estate for years will not prevent the freehold from uniting with the inheritance, when the freehold and the inheritance meet in the same person, so as to confer a title by courtesy or dower without prejudice to the term. In Bates' case, a person was tenant for his life, with remainder to trustees for a term of years, with remainder in fee to the tenant for life, and he died, and it was ruled that his wife should be endowed, notwithstanding the intervening estate, for that being for years was not to be regarded. If an estate of freehold, however, intervene between the estate for life and the inheritance, then there will not be any merger. Thus, in Duncombe v. Duncombe, a man was tenant for his life, remainder to a trustee for his life, with remainder to himself in tail, and it was decided that his wife was not entitled to dower. The ground of this determination was, that the trustee had an actual interposed estate for life, and not merely a possibility, and this measne estate kept the two estates of the husband distinct, and prevented the attachment of a title of dower. And in Stevens v. Bretridge the husband was tenant for his life, remainder to his wife for her life, remainder to the husband in tail, and it was held that the estate of the wife was a measne remainder between the estate for life and the estate tail of the husband, and it cannot be intended that when an estate for life is limited to the wife, that this should instantly merge in the estate of the husband. And when an estate is limited to a for life, remainder to B for life, with remainder to a in fee, the intervening estate of B will prevent the merger of the estate of A, but if the intervening estate of B is conveyed to a, the three estates will be united and become one entire interest in fee simple in possession in a. If there be a devise to the heir for life, the descent of the immediate reversion to him will merge his life estate, but a life estate cannot merge in a mere right to the reversion. So, in an action of sire faces upon a fine, it appeared by the arguments that, where a fine is levied to husband and wife in tail, the remainder to N. in fee, and the husband dies without issue, the feme being now tenant in tail after possibility of issue extinct, leases her estate, read for the period of her life, to N. who had issue and died. The issue shall not maintain sire faces to execute the fine because the lease to N. the ancestor was a surrender. And so also a life estate will merge in any estate tale, for an estate tale of any denomination is an estate of inheritance, and larger than any estate of mere freehold, and by the accession of an estate for life to an estate tale, the estate for life will be so completely annihilated that the fee will come into possession immediately on the determination of the estate tale by the death of the tenant in tale without issue, though the tenant for life should be still living. Thus in sire faces by the heir of J.S. to execute a fine, under a remainder limited to his ancestor, it appeared that a fine was levied to A. for life, the remainder to I. in tale, the remainder in fee to J.S. A. surrendered to I. and J.S. died, and I. died without issue. The plaintiff brought his sire faces as the heir of J.S. to execute the fine, and the tenant pleaded that after the death of J.S. I. entered, whose estate he had, and so the fine was executed, and Finch, contrary to Thorpe, held that it was a full surrender, and that thereby the estate of A. was merged in the estate tale, and the estate tale of I. executed, and his wife dowable. The case supposes a surrender in fact. In this respect the law on surrender and on merger stand precisely on the same footing, and it may be observed here, that when once an estate is merged it cannot be revived in favor of the person from whom the estate passes absolutely into the tenancy of the person by whose estate it is merged, but it may have continuance as far as creditors on the estate are concerned. With regard to the merger of estates for life in each other, or, to consider the question more generally, whether merger may take place between estates of equal amount or value in the eye of the law, is a point upon which there is some controversy. In the third resolution in Lewis Bowles' case, it is said that a tenancy in tale after possibility, and C. is not a larger estate in quantity than, and therefore cannot merge an estate for life, and there is a passage in Lord Coke to the effect that if a man leaseth to A during the life of B, remainder to him during the life of C, if he commit waste, an action of waste shall lie against him. These are authorities of considerable weight, and upon them one able writer has contended that this doctrine, viz. that there cannot be any merger as between equal estates of freehold, is not only favoured but established. Mr. Preston, however, lays it down broadly, that one estate for life may merge in another estate for life, and cites Shepherd's Touchstone, 32, neither at this nor at the other page referred to, p. 341, can the present writer find any passage to warrant the statement of this doctrine as made by Mr. Preston. And indeed it would seem to be no more than an assertion of that learned writer. He subsequently observes, it seems perfectly consonant with the rules of law that an estate for the life of one person should merge in an estate for the life of another person. Even when neither of these estates is for the life of him who has the more remote interest, viz. the estate in reversion or remainder, yet see Lewis Bowles' case, 11 Rep. 77, third resolution, and here if law. Thus, in some cases it may happen that there is tenant for his own life, remainder or reversion to another person for the life of a stranger, and it should seem on principle that the estate for life in possession would, on its vesting in the owner of the estate for life in reversion or remainder, merge in the estate in reversion or remainder, for, as to the owner of the estate in reversion or remainder, that estate, and the estate in possession, are both of the same extent. As neither of the estates is for his own life, each estate is in point of law equally valuable to him, and of the same extent, comprising the same relative degree of interest. Notwithstanding the preceding authorities, which are observed upon by Mr. Preston, he draws the conclusion that equal estates will merge, but it would seem that the authorities, as far as they go, do not afford a negative to the proposition that equal estates cannot merge in each other, but rather affirm it. This, however, must be understood with reference to estates of freehold. As to estates tale of equal value, Mr. Preston himself writes, a question to be examined is, whether one of two estates tale may merge in another estate tale, when the line of succession under each entail is precisely the same, and the reversionary estate is coextensive with the preceding estate. Unless these circumstances concur, there is every reason to conclude that the estate tale would not merge. It should seem that it would not merge under any circumstances, for it may be to the prejudice of the issue entail, especially where the title to one estate tail is not as good as the title to the other estate tail. It must be observed that there is some ground for Mr. Preston's contention, when it is considered that a term of years will merge in a reversion for a shorter term of years, and that one estate by elegit or statute may merge in another. The authority, however, of Lewis Bowles's case, seems hitherto unquestionable. It is an authority against the merger when the one estate is in remainder to the other. The opinions of both these learned writers may, perhaps, be reconciled by considering that there is a valid distinction between the cases of the life estate being in reversion or in remainder. In both Lewis Bowles's case and in the passage cited from Lord Coke, one estate was in remainder to the other, and on the passage from Lord Coke Mr. Preston threw out the observation, that if the two estates do continue distinct, this may be another difference arising from a remainder as distinguished from a reversion. This distinction recognizes the principle upon which merger is founded, and the correct statement of the rule may well be that equal estates, of freehold, the one in possession, the other in remainder, meeting together in the same person, will not merge. This view is supported by the able writer of the chapter on merger in Cruise's Digest. In the late case, however, of Crevy, Blood, a different view seems to have been taken of this question. Sir E. Sigden, then Lord Chancellor of Ireland, in delivering judgment in that case makes the following observations. It is said that two estates of the same extent and nature cannot exist together, and that one of them must merge in the other, and therefore, it is argued that the estate which Robert Cray had under the lease of 1740 merged in the like estate in reversion, for the same life which he had under the lease of 1766. It is admitted that for this there is no direct authority, and the cases stand upon grounds which require great consideration. Lewis Bowles' case, and Williams v. Williams, and the other cases of that class, were not cases in which one estate was first created and then a second, but they were cases where the original instrument contained a series of limitations, and intervening estates having been removed by subsequent events, the question was whether one estate in the line of limitations merged in another estate in the same line. In Williams v. Williams the court evaded the question. The King's Bench, in answer to the case sent to them, say that Catherine Williams became tenant in tail after possibility of issue extinct, but when, or whether by operation of merger, or by the union of the two estates is not stated. Suppose an estate were limited to a for life with remainder to the heirs of his body, that is, an estate in tail, in possession, in a. The two estates coalesce. So in Williams v. Williams, it cannot be doubted that if the two united, Catherine Williams became tenant in tail after possibility of issue extinct. The question then was, whether or not she was dispunishable of waste. But whether the court held that the two estates united or that the one merged in the other, we have not sufficient grounds to determine. Here, however, the difficulty is of another nature. The two estates were created at different times. A lesser estate may merge in the greater estate in remainder, but in this case the two estates are equal, or rather identical, and although the lease of 1766 might operate as between the lessor and lessee, yet the question remains, could it so operate as to create an existing life estate per autrui in the heir of Pierscre by descent, that heir having the very same estate by descent from his mother under a previous title? The law would do a vain thing if it merged the prior existing estate in favour of an estate of the same quantity created by a subsequent instrument. The title of the heir was perfect, as heir ex parte maternam up to the death of his father. His father died seized of no greater estate than the heir then had. Merger must be in the sense used in this case of a lesser interest in a greater, of a possession in a reversion. The same person cannot have in the same lands two estates for the same life, one immediately expectant on the other. But why the first should merge in the second I do not at present see. It is a point of novelty which I am not called upon to decide. With reference to the latter part of these observations, it must be borne in mind that merger is the drowning of the estate in possession in the estate in reversion, and that it operates to accelerate or bring into possession the ulterior estate. All estates for life are not equal. For instance, an estate for the life of another person, more commonly known by the appellation of an estate per autrui, is, as to the tenant himself, accounted of less extent than an estate for his own life, and therefore, an estate for the life of person will another merge in an estate which a man has for his own life. And if a lease is made to one for the term of another's life without impeachment of waste, the remainder to him for his own life, now he is punishable for waste, for the first estate is gone and drowned. It is immaterial whether the estates are created by the same or different deeds, and the merger will take place notwithstanding it was most clearly the intention of the parties that the same person should have the land for the several times of enjoyment expressed by the different limitations of the respective estates. When a has an estate for his own life and a remainder for the life of another person, then, whether these estates are derived under several imitations to him in the same instrument, or from several imitations in distinct instruments, there will not be any merger of either of these estates. The estate for his own life will not merge in the estate of which he is tenant for the life of another person, because the estate for the life of that person is less than the estate for his own life, and the estate for the life of the other person will not merge in the estate for his own life, because the estate for his own life is the larger estate, and first in order of time, and merger requires that the estate in possession should be absorbed by the estate in reversion or remainder. In Lewis Bowles's case it was said if a lease be made for the term of another's life, without impeachment of waste, the remainder to himself for his own life, he is punishable for waste, and the reason assigned in the report is, that the first estate is gone and drowned. That it was gone or drowned, was the consequence of the merger. When an estate is granted to an individual for several lives, as for the life of himself and of another person or persons by one entire limitation, this gives only one estate, with one undivided time of continuance, and not several and distinct estates. It follows, that there will not be any merger of the time for one life in the time for another life. In Ross's case, a lease was made to A, and his assigns, habendum to him during his life and the lives of B and C. The question was, whether this grant during the lives of B and C was void. The decision was in favor of the limitation. It was objected, that when a man had two estates in him, the greater should drown the less, and that an estate for the life of the lessee was higher than for the life of another, and that therefore the estate for his own life and for the lives of others could not stand together. The answer given, and resolution of the court were, that the lessee had only one estate, which had this limitation, sil, during his life and the lives of the two others, and that he had only one freehold, and, therefore, there could be no drowning of estates, and the opinion of the court was, that the lessee had an estate of freehold to continue during their 3 lives, and the life of the survivor of them. It is to be observed, however, that if in this case the lease had been for the several lives by way of distinct and successive estates, one of those estates might have merged in another of these estates. This is evident from the doctrine deducible from Lewis Bowles's case establishing, that if A, by several imitations, even in the same deed, or in distinct deeds, hath an estate for the life of another person, with an immediate remainder to himself for his own life, the prior estate will merge in the remainder. On this point the following distinctions may be considered as settled. First, when a lease is for several lives, as one undivided and entire point of time, the time of one life cannot merge in the time for another life, because there is one estate or time only, and not several and distinct estates or times. And, secondly, when a lease is for several lives, at distinct periods of time giving one estate in possession, and other estates in remainder, then ceteris paribus, there is scope for the application of the doctrine of merger, because there are several estates, but still the doctrine cannot operate unless the estate in remainder be larger than, or as large as, the estate in possession. Therefore, when A is lessee for his own life, with remainder to him for the life of B, this doctrine cannot affect either of the estates, since the estate in possession which is for his own life, is larger than the estate for the life of B, which is for another life. It is possible that a man may have an estate for the life of a stranger, and that another person may have an estate in reversion or remainder for the life of the former tenant, or the order of their estates may be changed, and the estate in possession may belong to another person and be held for the life of the reversioner or remainder man. When this happens, and both estates meet in one person, it may be questioned, says Mr. Preston, whether any merger would take place. No decision has occurred on this point. The greater probability is, that the estate in possession will merge. Every requisite for merger seems to concur in this case. At the time when the doctrine of merger is to operate, if it can have any effect at all, the two estates are immediately expectant on each other, and the estate in reversion or remainder is, as to the owner of that estate, as large as or larger than the more remote estate is as to the owner or tenant of that estate. But this is a nice point, especially when the second estate is a remainder and not a reversion. Under these circumstances the estates appear in all respects to be equal. It is doubtful also, he observes, when there is an estate for several lives, and another estate merely for one life, and these estates meet in one person, whether the estate in possession will merge. It may be objected, that the estate for several lives is larger than the estate for one life. In this objection there is apparently great weight. No authority has occurred from which the law applicable to this point can be stated. It is likely that, following the primary grounds of the law on merger, the courts would incline to the opinion, that the determinations on merger are sufficiently strong to bring this case within their influence. But the point is surrounded with too many difficulties to admit of any certain conclusion. The argument in favor of merger is, that this is a step towards the acceleration of the reversion and alters the privity of tenure. In Phillips v. Phillips, an existing estate pour autrui, was limited to one for the life of another, and was not allowed to merge in an estate which the party had to her and the heirs of her body, but on her death, without heirs of her body, her executors and administrators became entitled as occupants, in exclusion of the heir claiming by resulting trust and the remainder man or reversioner. The estate tail was a legal estate, whilst the estate for life was an equitable one, and, therefore, could not merge in the legal estate of inheritance, nor will a legal freehold with an equitable estate of inheritance. An estate for life and a remainder for years may continue in the same person unaffected by the doctrine of merger. An estate for life will not merge absolutely in an estate tail, or in an estate in fee, when the owners of these estates join in conveying the same by one deed to another person. In Breden's case, a tenant for life joined with the first remainder man in tail in levying a fine zur Nuisance cum CEO, and c. to another in fee, rendering a rent charge of £40, and the first tenant in tail died without issue in the lifetime of the tenant for life. The second tenant in tail entered as for a forfeiture. The tenant for life distrained for the rent charge, and the principal point agreed on and determined by all the judges of the common pleas was, that the fine levied by tenant for life, and by him in the first remainder, was no discontinuance, but that each of them gave only that which he might lawfully give, viz. the tenant for life gave his estate, and he in remainder a fee simple determinable, and judgment was given in favour of the tenant for life, who had a return of the cattle distrained after they had been repulved, on the ground that there was not any forfeiture, and that the rent, and of consequence the title or seisin under the tenancy for life, continued after the death of the tenant in tail without issue, or, in other words, that the estate for life was not merged by its union with the next estate of inheritance. And in Terreport's case it was said, by Popham, C.J., if tenant for life and he in the reversion make a gift in tail, rendering rent, the lessee shall have the rent during his life. This, of course, was an admission that the estate of the tenant for life was a continuing ownership, for, unless that estate existed in point of law distinct from the inheritance and not confounded in the same, the rent could not have belonged to the tenant for life, and Popham, in terms still more express, declared it to be his opinion, that, if tenant for life, and he in the reversion had made a faufement by deed at the common law, the faufee should hold of the lessee during his life, which proves in a manner the most incontrovertible that the estate for life was not destroyed, for supposing it to have been destroyed, the tenure must have been of the reversioner and not of the tenant for life. From this opinion it must be collected, that if the estate tail had determined in the lifetime of the tenant for life, the right of possession would have been in the alienee under the estate for life, and not in the reversioner, till the estate formerly of the tenant for life was determined by his death, or some other means. The case of the Earl of Clanricarde also confirms this doctrine. In that case a lady was tenant in tail, with reversion to her husband for life, and they joined in a fine, and it was contended that this fine was a discontinuance by the tenant in tail, and so the estate for life did drown and extinguish itself in the fee simple granted to the connoissee. The argument on the behalf of the demandant was, that when the estate tail determined, the demandant's reversion was to come into possession, as the estate for life was extinct in the estate given by the fine, and that the fine should not, as to the estate for life, operate to the benefit of the connoissee, but of the old remainder or reversion. Sir Henry Hobart, in giving judgment, observes, "The estate for life doth not pass drowned in the tale as giving place to it. But it is true that both the estates that were in them several did pass from both as distinct authors of the new estate, according to their measures. But now in the connoissee they are but one entire estate made of two, and therefore remove the confusion, as chemists do, by extracting and segregating the simples of a compound, as, suppose this conveyance were upon condition, the entry shall restore their estates as they were before. So, in English's case, in Braddon's case, the connoissee took two estates, and from two givers, tenant for life and an infant in remainder by fine. The connoissee now had but one estate, yet upon reversal of the fine the law restoreth no more to the infant but the remainder, because he gave no more, yet the estate for life was as in this case given, confounded in the fee, and no forfeiture made in English's case. So in this case I hold it clear, that if an infant tenant entail in possession, and he in remainder for life, had joined in a fine, and the infant had reversed his fine, yet the remainder for life should have vested with the connoissee. In the case of Major v. Talbot, the plaintiff held the possession and had the cause of action in right of the wife, while he brought the action as assignee of the husband, and when the court treated the wife's life estate as merged, they meant nothing more than united to and consolidated with the inheritance in that case. The true ground of the judgment is given in Croke, that the action was well brought, being brought by the assignee of him who hath the inheritance, and so no prejudice to any, and the estate for life being transferred with the fee is thereby drowned and confounded, so as he being assignee of the whole estate and showing all the matter is good enough, not that the action was in the most approved form, but in a form which in the pleadings at large was sufficient, since he had shown his title as assignee of the wife as well as of the husband. And according to Sir William Jones's report, the judges agreed that each passed his own estate to the grantee, but he adds an observation that in regard to strangers who are to receive prejudice from the merger, the estate of the wife continues, so that if any rent charge or other charge was made by her, the grantee should hold this charge during the life of the wife, but in truth the particular estate was merged in the reversion in fee. It is then added, this is no prejudice to the lessee for years, for he is subject to a covenant, as well after the determination of the estate of the wife as in her life. On this decision it is also observable that the estate was drowned and confounded, as far as it had been a distinct estate, although it was continuing in point of title, for after the husband and wife had conveyed to a third person, there ceased to be any existence of the freehold, distinct and separate from the inheritance. The conclusion Mr. Preston draws from these cases is, that when two persons, each having a several estate expectant on the other, convey the land in which they have those estates to one person by the same conveyance, though the estates will be consolidated and no longer distinct, yet the land may be held under this conveyance until such time as both the estates would have severally determined if they had continued in the tenancy of distinct persons. It is otherwise when a merger takes place. The merger of the particular estate in the reversion causes the determination of the right of enjoyment under the particular estate, without respecting the period to which this particular estate was extended and might have continued if the estates had remained distinct. An able writer, in commenting upon the proposition founded upon the authorities of Braddon and other cases here cited, observes that if Braddon's and the other cases turn solely upon the intention of the parties, they must be considered as anomalous instances of the intention preventing the legal consequence of the union of two estates in the same person in the same right, but it is submitted, that the principle upon which these cases may in a measure depend is, that one of the two estates being in possession and the other in remainder and not in reversion, there is nothing incompatible in their union as continuing interests in the same person, since that union does not involve the inconsistent relations of dominus et tenens. The intention of the parties is not the governing principle of merger, for while in some instances the law of merger from favor to the intention of the parties is held to be inapplicable, yet in others merger is consequent upon the union of two estates in direct opposition to the intention of the parties. either apparent or implied. Perhaps no general rule in reference to the intention can be deduced, which would embrace every instance, but it is suggested as in some measure tending to a classification of the cases, that merger in reference to the intention is excluded chiefly in those instances where the two estates which would otherwise merge are created by the same instrument, or at the same time, or by the same contemporaneous transaction, but that where two estates unite in the same person, not as above noticed, at the same time and by the same deed or transaction, but at a period subsequent to the original creation of the estates, and by a distinct act of law or of the party, there, in most instances, merger will be the consequence of union, without regard to the intention of the parties. There are, however, some instances where union of estates takes place irrespective of any manifestation of intention whatsoever in reference to merger, and merger is not uniformly the consequence of union in such instances. From the authorities before cited, it would seem to follow that when the several owners of estates for life in succession join in conveying the same to one person by one limitation, merger will not take place, but the conveyance will operate to give one united estate to continue for the several lives. The observations of Sir W. Jones in the case of Major V. Talbot, relative to the estate of the wife continuing so as to preserve a rent charge granted by her, lead on to the consideration of the effect of the merger on interests created by the tenant for life, or arising out of his estate. Although an estate for life may be merged by its union with the inheritance, yet persons who have interests affecting it will be left in the same condition in point of benefit as if no merger had taken place. Thus, if the tenant for life has made a lease, or has granted a rent charge, or confessed a judgment, such lease, rent or judgment will remain in force, and affect the land during the period of the estate, which is merged in like manner as if that estate had continuance and the merger had not taken place. For the purpose of these estates, the estate for life, though merged, has continuance in point of title, although it is merged in point of law. It would be inconsistent with the principles of justice, that a man should by his own act discharge himself from his own lease or other encumbrance. In Archer's case, a tenant for life had made a faufement which operated as a forfeiture of his estate for life, and Lord Coke makes this observation note, reader, after the faufement, the estate for life, to some purpose, had continuance, for all leases, charges, and made by the tenant for life shall stand during his life, but the estate is supposed to continue as to those only who claim by the tenant for life before the forfeiture, but as to all others who do not claim by the tenant for life himself, the particular estate is determined. In Sir Edward Peter v. Pemberton, where the grantee of a rent charge for life accepted a term of years which suspended the rent, and then surrendered the lease, it was held that on the surrender the rent was revived. For the court added, by the surrender and agreement of the parties, the lease is absolutely determined, and not in SC, and none of them can say it is in SC, but a stranger, who is to have a benefit thereby, may well say it is in SC as to him, but the lessor and lessee, it is determined, and the possession and interest is in him without entry. In Podger's case it is said, if tenant for life granteth a rent charge, and he in reversion granteth a rent charge to another, and afterwards the tenant for life surrendereth, the grantee of the tenant for life shall be preferred. This principle of preserving the charge after the merger of the estate for life applies equally to estates for years. Estates for years, however, after merger, would cease to be legal assets, which the creditors could follow by suit at law. With regard to the estate in which the merger takes place, the effect of the merger is to subject the reversion or remainder thus accelerated to all those burdens and consequences which would have attached on that estate in case the prior estate had not existed, and in the same order or series of time as if that estate were determined. Thus the possession will be chargeable, during the period appointed for the continuance of the particular estate, with all the encumbrances which affected that estate, and also, by way of acceleration, with the encumbrances which attached on the reversion or remainder as thus accelerated. Thus in Errington v. Errington it was said by Doddridge, if tenant for life grants a rent charge, and he in reversion also grants a rent charge the tenant surrenders to the reversioner, the land shall now be presently charged with 2 rents, and Coke, c. J, agreed the same to be so, and with reference to an estate merged, the Chief Justice admitted that the merged estate should have continuance against all strangers, and Doddridge added, "True it is that as against all strangers which do not claim under him, it shall have continuance, but not against others." Formerly, when a tenant for life made a lease for years at a rent, and the estate for life became merged, so that the relation of landlord and tenant ceased as between the parties, the remedy for rent and for covenants annexed to the reversion ceased with the reversion to which the rent and covenants were annexed and incident. And in this respect the interest created by the tenant for life might be benefited, but now by the ninth sect of the 8 and 9 Vict. c. 106, it is enacted that when the reversion on a lease shall, after the 1st of October, 1845, be surrendered or merge, the next estate is to be deemed the reversion expectant on the same lease to the extent and for the purpose of preserving such incidents to and obligations on the same reversion as but for the surrender or merger would have subsisted. With reference to husband and wife, where the wife has a life estate, in Purifoy v. Rogers, it was agreed that the estate of which the wife alone was seized, was merged by the accession and acceptance of the fee to her and her husband as tenants by entireties. Thus, although the wife be solely seized of the freehold, yet on the purchase of the inheritance by her and her husband, the entirety of the freehold will merge in the inheritance. The wife, however, if she survive her husband, will have a right to restore herself to the freehold by waiving the inheritance. It should be observed that tenancy by entireties is peculiar to the ownership of husband and wife, and owes its qualities to the unity of their persons. Each in intendment of law has the entirety, and a particular estate in one of them of the entirety may merge in the reversion or remainder of that person, for each has a power of alienation over the entirety, subject only to the right of the other. This tenancy exists only when a conveyance is made to them during the coverture, and since neither can alien to the prejudice of the other, it is but reasonable that there should not be any absolute merger of the estate of the wife. When the husband has an estate of freehold in his own right, and the fee in right of his wife, the freehold will not merge, and, therefore, where a woman seized of land in fee, leased the same to a stranger for life and took a husband, and the lessee granted his estate to the husband, no surrender was effected, and yet the husband was seized of the reversion in fee, which was immediate to the estate of the lessee, viz. In right of his wife and not in his own right. Neither will the freehold of the wife merge in the freehold of the husband. But where the husband has the freehold, and also the fee in right of his wife, and there is no particular reason, as joint tenancy, tenancy by entireties, and c. to keep the estates apart, there the estate of freehold will merge in the fee, and it will be immaterial whether one of these estates be an accession to the other by the concurrence of the husband, or merely by the act of law. In each estate the interest of the husband is equally extensive and equally beneficial. He can receive no prejudice from the application of the doctrine of merger, and therefore there is no ground for allowing the exception in such a case. We have already seen that when one of these estates is vested in the wife by entireties, merger will not take place. It is highly probable that an estate of freehold held by an executor or administrator in right of a testator or intestate will not merge, and upon the ground that the estate is an accession by the act of law. In the chapter upon estates for years, we shall have occasion to refer at length to this ground of exemption from merger. With regard to contingent remainders, an estate for life was exempted from merger in the fee when the consequence of such merger would have been to destroy a contingent remainder intervening between the estate for life and the ultimate fee. The cases cited below fully established this exemption. To prevent the destruction of contingent remainders, it was necessary, however, that the two estates should be limited by the same instrument and commence or take place in the same instant of time. But where the estates did not take effect in the same instant of time, as where the reversion or remainder acceded to the particular estate or the particular estate acceded to the estate in reversion or remainder by the act of the parties as by express limitation or by operation of law as by descent, merger took place, and the contingent remainders were destroyed. Since the passing of the Act 8 and 9 Vict. c. 106, the consideration of this point in the doctrine of merger has become unimportant, as by the 8th section of the Act, contingent remainders can no longer be destroyed by the merger of the particular estate. The section of the Act is as follows: that a contingent remainder existing at any time after the 31st day of December, 1844, shall be, and if created before the passing of this Act, shall be deemed to have been capable of taking effect, notwithstanding the determination by forfeiture, surrender, or merger of any preceding estate of freehold in the same manner in all respects as if such determination had not happened. Where lands are limited to two persons for their lives as joint tenants, and the reversion in fee subsequently devolves upon or is purchased by them, so that they hold both estates in joint tenancy, or by entireties, the doctrine of merger is applicable. So when a grant is made to two jointly for their lives and the reversion is afterwards purchased by one of them, there will be a merger for a moiety and a severance of the joint tenancy. So when a man has an estate for life and accepts a grant to him and another jointly in fee, there will be a merger for one moiety and a severance of the joint tenancy. And in like manner there will be severance and merger when tenant for life grants his estate for life to one of two persons who are joint tenants of the immediate reversion or remainder in fee, for the reversion or remainder man cannot be tenant to himself. It has also been held, that when the reversion descends to one joint tenant for life, or the one joint tenant for life purchases the reversion, the jointure is severed and the estate for life drowned, and not like where two purchase to them, and the heirs of one of them, for there the agreement at the beginning was that the estate should continue, and it was cited to be so ruled in Morgan's case, and that it was ruled between Portley v. Portley, that it was all open, where the one purchaseth the reversion, and where the reversion descends to the joint tenant. A tenant for life of 1/3 accepted a conveyance of the entirety to himself, and a trustee, and the heirs of himself, there was a severance for 1/3, and the wife became dowable. He ought to have joined in the conveyance and to have raised the joint tenancy by an use. Again, if tenant for life grant his estate to one of two coparceners, this is a merger only for a moiety. But if the be lessee for life and the reversion descend unto two coparceners, and one of them take husband, and the lessee grant his estate unto the husband and wife, the same shall inure by way of grant for the whole. This is in order to preserve the interest of the husband. When one of several persons being a joint tenant or tenant in common of the freehold, accepts a grant to himself jointly with one or more person or persons, being a stranger or strangers, there will be a merger, and there will be a merger only to the extent of the share in which this person has an equal share in the freehold and also in the inheritance. But there will be no merger, and consequently no severance of the joint tenancy when all the estates are limited by the same deed, and the consequence of the merger would be to destroy the quality of one of two estates limited by the same deed. Thus in Rogers v. Downs, two persons were joint tenants for their lives, with remainder to their heirs as tenants in common, and the joint estates for life were protected from merger. So if the grant be to several for their lives as tenants in common, with remainder to them in fee as joint tenants, the inheritance will remain in joint tenancy. In Wiscott's case it is laid down, when the fee is limited by one and the same conveyance, there the one may have the fee simple and the other an estate for life jointly, but when they are first tenants for life, and afterwards one of them doth get the fee simple, or the fee simple doth descend to one, there the jointure is severed, as if a man maketh an estate to three and to the heirs of one of them, there one of them hath the fee simple, and yet the jointure doth continue, for all is but one entire estate created at the same time, and therefore the fee simple cannot drown the jointure which took effect with the creation of the remainder in fee. But when three are joint tenants for life and one purchaseth the fee, or the fee descendeth to him, there the fee simple drowneth the estate for life, for the estate for life was in esse before, and might be drowned or surrendered, and so cannot the estate for life in the first case. But in the same case, that is to say, when an estate is made to three and to the heirs of one of them, and he who hath the fee dieth, and one of the survivors purchaseth the remainder, the jointure is severed causaque supra, and when one tenant for life purchaseth the reversion in fee, if the jointure should remain, he should have a reversion in fee and an estate for life also in part, which reversion fee he may grant over, and his estate for life should remain in part, which should be absurd and against reason, for in the first case, when an estate is made to three and the heirs of one, he who hath the fee cannot grant over his remainder, and continue in himself an estate for life as it is holden in 12e. 4, 2b. It is agreed, 39, h. 6, 2b, if the reversion be granted to tenant for life, and another in fee, the reversion is extinct for a moiety, for tenant for life cannot purchase or get the reversion or remainder of the same land, but the estate for life shall be drowned, having regard unto the estate which he hath gotten in reversion. Note, reader, it seemeth by the resolution in this case, that if tenant for life granteth his estates to him in the reversion, and a stranger, that the same is a surrender for one moiety, for it appeareth here that by getting of the reversion and the particular estate at several times, the reversion expectant on his particular estate for life cannot remain distinct in him and grantable over, but the one shall drown the other, and benefit of survivorship not regarded as it appeared in the case at bar, and so the doubt in 7, h. 6 will resolve, I think. It follows, therefore, as a rule, that as to joint tenants and tenants in common, merger will not operate beyond the extent of the part in which the owner has two several estates. Thus, if A be tenant for life, remainder to B and C entail or in fee, and A convey his estate to B or C, the estate for life will merge to one and continue as to the remaining moiety of the same land. So when A and B are joint tenants or tenants in common for life, remainder to C in fee, and A conveys his estate for life to C, there will be a merger as to one moiety only of the land, and B will be tenant for life of the other moiety. After merger B and C will be tenants in common of the freehold, and C will have the inheritance of one moiety as tenant in fee in possession, and of the other moiety as tenant in fee expectant on the decease of B. Again, if A and B are tenants in common in fee, and A settles his moiety on C for life, and B settles his moiety on D for life, and the reversion of B descends to C, the several estates of C will remain distinct. These estates exist in an equal share of the same lands, but they clearly exist in different shares. This is the protection of the particular estate from merger. As between these estates there is not any connection or privity in title, no dependence of one estate on the other. The estate for the life of C is derived from the title of A, while the reversion in fee is derived under the title of B. It is therefore impossible for one estate to blend with the other. There is a want of that privity of right and of title which is essential to merger. The privity and connection of title as to the life estate of C is between C and A, or those who claim under him, and as to the reversion in fee, it is between C and D. Merger requires that the several successive estates shall relate to the same share. If two persons, being joint tenants for life, have an estate which, by its constitution, will continue for their joint lives and the life of the survivor of them, yet on a severance of the joint tenancy the moiety of each will be held for his life only. These distinctions occur. 1. If both join in a grant the estate will continue for their several lives. 2. If one make a lease for years, the lease may, unless the joint tenancy be severed, continue until the death of the survivor. 3. One may release to the other. The quantity of the estate of the release is not easily ascertained. It should seem to be for his own life only, and on a grant by either or by each separately to a stranger, the stranger will be tenant of the moiety, which is granted for the life only of the grantor.